Watching ENCA, I'm Tembekile Mkhototo. Great to be in your company. We're taking you back now to one of our top stories, and the High Court in Pretoria has dismissed a bid to halt the reopening of schools. That challenge was brought by the One South Africa movement led by the former DA leader Mmusi Maimane. The organization says children should not continue to go to class as the country grapples with COVID-19, especially ahead of the peak, and it wants the country to return, it wanted at least the country to return to level 4 of the lockdown. Let's speak to Mmusi Maimane himself. He's joining us by Skype this afternoon. Mmusi, great to see you. So you are disappointed, but you're not giving up this fight from what I've seen on your social media. Am I right?
Good afternoon, and certainly not. It's an important fight. It's an important fight in the context of what's going on in our country. It's very clear the fact that infections are on the rise. It's very clear that now, as the Eastern Cape has just released its own reports, that learners can be able to contract the virus, teachers are getting the virus. So I think we've got to ask ourselves as a nation whether is the right to life, as guaranteed in the Constitution, being willing to be weighed against other rights. And therefore, that becomes a seminal question. We're studying the judgment. It is a disappointing judgment because ultimately we fight to make sure all schools in this country are safe. This is about learners in Limpopo. This is about learners in every community in the Eastern Cape who don't have running water, who don't have PPEs, whose schools are not safe. So this is a fight that is worth fighting for us as a country. Anyway.
You speak about rights, and having just scanned through part of that judgment, one of the things the High Court talks about is that you've not been able to show that government has at this stage violated any of the rights that you list in your application. Do you have new evidence of that since the time when you lodged your application?
Well, if you follow the what's been going on, you'll realize very clearly the fact that when we made our case, we were making a case from the 1st of June. You'll recall that South Africa's infection rate had not reached the levels that it is. When we argued the case about the right to life, which is a constitutional case, in fact, none of the opposing sides made that right. It was a question of saying, what other rights are we contesting against, is the argument that we should put. Is the right to life must be made equal to any other right in the Constitution. We argued strongly that it remains supreme, that in fact you cannot educate kids that are not alive, but you certainly can make sure that kids stay alive so that you give yourself an opportunity to educate them. So we still hold that view, and we hold that view for all citizens in this country. That's why we think that it's worth looking at this judgment and studying it carefully and making decisions subsequent to that. Whilst disappointing the fight is, I think now equally so, our lines are still open. We are asking, we're appealing, we're speaking to parents, we're speaking to government to say to them, can you satisfy yourself that the decision to send our kids back to school still remains rational and still is in the best interest of all our citizens and all our children, considering that our peak is only really scheduled to come through in August and September. And then lastly, when the Department of Basic Education argued in court, they touted evidence that said that kids could not be carriers. And I'm sure you've seen in your report that has just come out now that provinces are reporting that learners are contracting the virus. And if I'm not mistaken, it's the Eastern Cape who've just tragically lost learners to COVID.
And the argument, again, it's a medical argument, but also highlighted in this outcome from the court. The High Court saying that the issue with COVID-19 is that whether children are allowed to go back to school or not, the numbers rising is something that is inevitable. The court then goes on to say that government's plans appear comprehensive and sufficiently detailed. I want to ask you then about your specific faults that you have as far as what government has detailed in its plan to try and minimize the risk as far as possible, because the idea now is to minimize risk, not eliminate it completely.
Well, the argument that we made in court is that, and this is a view of a court, you might consider another court might come to a different finding about the implementation plan, which was the fundamental argument. You will recall that when this matter was taking place, there was 1 week where the very same government said, we've got sufficient plans, and then through consultation said, no, we want to give ourselves another week. And it is the same government that's equally continued to say, we have plans. They had plans to deliver textbooks. This is never the debate. The debate is whether those plans are being implemented or not. That's why we went to court to say, give us a supervisory order that can ensure that those plans are vetted by someone else. You can't have the department saying, here's our plans, we'll monitor ourselves and we'll make sure we pass ourselves. We are simply saying that whose child actually should we now be sitting around going, well, in school X, in a community that is poor, whose child should that one be, where we can say, oh, we only wish that school had PPEs, or we only wish that school had running water, or we only wish that school had proper toilets? Whose child are we willing to pronounce on that in South Africa today?
Based on that, then, is it safe to assume at this point that you will, in all likelihood, appeal this judgment?
We are looking at the judgment carefully. Of course, we've got to appeal it in law when we look at the appealability of the judgment. But it's important that we consult with our legal team and then go from there.
Mmusi Maimane, leader of the One Movement, thank you for being on ENCA.